These families, they would pay everything, they'd give it all back just for 1 minute. That would be true justice.
Well, an emotional day, a landmark settlement. For the first time ever, a gun maker is being held liable in a mass shooting. Last night, Remington agreed to pay $73 million to victims of the Sandy Hook shooting. Now, the families of some of those victims sued, claiming the gun maker marketed its semi-automatic rifles to young men.
Yeah, the settlement is not an admission of guilt by Remington, though. But Sandy Hook parents say that documents in this case show what the company was actually doing. And joining us this morning with more on what this settlement means is Timothy Lytton. He is a law professor at Georgia State University. Hey, thank you for coming on this morning. We certainly appreciate it. You know, what we understand is that the company was really marketing towards these younger men. How concerning was that to a lot of the parents in this case?
I think the basic gist of the parents' concern was that the firearms manufacturer, in this case Remington, was trying to not just sell its weapon as, you know, suitable for self-defense or a really good sporting firearm, but really sort of pushing it as a kind of rite of passage into manhood, glorifying the kind of violence that we see in these sorts of mass shootings with these weapons. And I think that they were aiming to get the attention of the firearms industry to look more carefully at their marketing campaigns to see whether or not, in some cases, they're doing things that might sort of stoke passions that could lead to these sorts of events. Whether or not that connection is entirely clear, I think, was never established because this case never went to a jury. But I think that was really the gist of the complaint that the parents in this case had against the Remington, the maker of the semi-automatic weapon that was used to massacre all the children.
One of the more fascinating components to this story, in my mind, is the fact that there's long been this firewall, thanks to lobbyists, the NRA. I mean, the gun lobby is so powerful, and yet they seem to circumvent the federal law using a loophole through a state law. I bring it up because, in my mind, that perhaps opens the door for other states to individually perhaps create laws that would allow other plaintiffs to go forward in the future. Would you agree?
We don't really know whether that door is open or not. The central legal question in this case, the one that you identified, has not really been definitively answered. In 2005, Congress passed a federal immunity shield for the firearms industry to protect it from any kind of lawsuit that arises out of criminal misuse of a weapon. And for the most part, that put an end to most of these lawsuits by gun violence victims against gun makers. In this particular case, there's an exception to the federal immunity bill. If the firearms manufacturer is selling weapons in violation of the law, in particular, it says a law applicable to the sale of a firearm, then the immunity is no longer there and the firearms manufacturer can be held responsible. And the question in this case is whether or not the statute in Connecticut that prohibits unfair trade practices, which is a general consumer protection statute, right, is a statute that is applicable to the sale of a firearm. Some courts have said applicable to the sale of a firearm in order to lift the immunity shield requires that the statute be specifically aimed at firearm sales. And the Connecticut Supreme Court disagreed and said, actually, it can be any kind of statute that can be applied to a firearm. The Connecticut Supreme Court, of course, is not the last word on how to interpret this federal immunity statute. That last word has to be with the Supreme Court of the United States. This question will never reach them from this case because the case is now settled. Whether or not another case will present itself that will allow the Supreme Court to talk about what the scope of liability exceptions are for the immunity bill remains to be seen. And that's really the question. So I don't think we're likely to see a flood of new litigation until that question is clarified at the U.S. Supreme Court. And until then, we're likely to see sort of a continued trickle of this sort of lawsuit against the firearms industry in the wake of these mass shootings. But I don't think it's going to change the landscape very much.
Interesting.
Yeah. Timothy Lytton, law professor at Georgia State University. Thank you so much for your time this morning.
My pleasure.